Welcome, everyone. My name is Howard Gould. I'm co-chair of the real estate section for the Beverly Hills Bar Association. Uh, Great to have everyone with us today for this program about the Davis-Stirling Act. I want to thank Michael Kushner for coming today. Davis-Stirling Act is hugely important when it comes to HOAs. And as we know, there's HOAs just all over the place in whether it's a high-rise building, low-rise buildings, single-family developments that have common areas, and these are common interest developments. And so Michael specializes in this area. He's the founding and managing partner of MBK Chapman, PC, and he is a pioneer in homeowner side HOA law in California. He protects homeowners from what he sees as abusive and mismanaged associations. He represents homeowners in disputes involving abusive boards of directors, selective enforcement, illegal fines, architectural denials, records violations, and other forms of misconduct by HOAs or their management companies. He's developed his own proprietary legal systems for enforcing the Davis-Stirling Act on behalf of homeowners. He's the author of HOA Hell, California Homeowners Definitive Guide to Beating Bad HOAs, which you can find on Amazon. Michael is a UC Berkeley grad and also a grad of the UCLA School of Law. And Michael, thank you for coming. Program's all yours.
Thank you, Howard. I appreciate you having me here. What I'd like to do first is share my screen because I'm going to kind of walk people through a presentation I hope they'll find interesting. I believe they're going to tell you later that we're going to make this entire slideshow available to everybody, as well as a 6,000-word article on the Davis-Stirling Act that is going to be available to everyone, and also a guide, an HOA guide. So with that, I'd like to start by just introducing myself. You know what? I think Howard did a great job, so I don't need to do that. Let's just jump into what we're going to cover today, or I'm going to do my best to cover today. Obviously, I'm going to talk about the Davis-Stirling Act, what that means, and I kind of broken it down into 8 different groups: the authority and the framework, the governing document hierarchy, open meetings and executive sessions, records access and enforcement, elections, discipline, and specifically AB 130, a law that went into effect last year, IDR and ADR, and architectural assessment. I go through a lot of code sections. Don't worry about writing them down or memorizing them. You guys are going to get all this anyway. So you could just listen, but I don't think you need to take notes or do anything, other than just listen and try to figure out what's coming next. So real quick, Davis-Stirling Act, in plain terms, it's our rule book. It's the rule book for California HOAs. And it's found primarily in Civil Code section 4,000 through 6150. And it governs pretty much every major aspect of life in any common interest development in California. And that includes how boards run meetings, how elections are held, how votes are counted, how rules are adopted and enforced, how members inspect records, disciplines imposed, assessments are levied and collected, and what to do if there's disputes and resolution of disputes. It also covers things like neighbor disputes and things like nuisance, and what the HOA obligations are vis-a-vis the HOA as an entity and each of the homeowners as well. But if you take one thing from this slide, at least, it's the core principle issue. Every single action that a board of directors takes in an HOA has to trace back to one of 3 sources: either the governing documents, California law, or specifically the Davis-Stirling Act, or any other federal or state law. So with that, Davis-Stirling is our foundation. It's where we begin everything. There's 2 common misconceptions about the Davis-Stirling Act. And one of them, and they're polar opposites. One of them is that it only protects boards, and that's not true. And the other is that it's purely homeowner centric. That's not true. Okay, a lot of homeowners believe in the former that it only protects boards for good reason. There's a huge difference in power, just based on the fact that the HOA collects money from everybody, so it has a big purse to play with, and it has the power to discipline, to fine, and or to suspend somebody's rights or privileges to utilize common areas. And so just based on what the law is designed to do, HOAs have this big power advantage. But the Davis-Stirling Act is written for both. It's written for homeowners and boards, and it gives homeowners a lot of protection. And so the reality here is it's a balance of power. Boards hold a lot of authority, but they are bound by statutory procedures about transparency and due process, and there are lots of statutory limits. And it's by understanding and educating our clients about those limits and those obligations that give homeowners ultimately the power that almost even up the playing field. Because most disputes actually come down to whether the board stayed inside the lines or obligated to stay inside. So Davis-Stirling Act is complicated. Not because it's hard to understand when you read individual statutes. Some of them are beautifully written and extremely easy, plain language, and other ones are like reading the tax code. But that's not why that's an issue. It's because it is a big set of statutes and things are found all over that set. So it's not a structural problem per se, but it's a unintegrated set of statutes. And so if you look at the spread on the screen, this is me organizing it as best I could. And this is a pretty good guide as to where you'll find the different aspects of the Davis-Stirling Act that you as a real estate attorney might want to know. So you've got open meetings. Generally speaking, you'll find stuff about open meetings between 4900 and 4955 of the Civil Code. You've got records, which you'll find at 5200 to 5240. And it goes through elections, discipline, IDR and ADR, architecture, assessments, reserves, and disclosures. Now, again, those aren't really official separations. Those are just based on my experience, what I came up with, but they're pretty close to this. It's a fragmentation, though, and that's the practical barrier. And before I go scheme by scheme, and I do want to try to hit all of these, I want to give you a single analytical framework that sits above all of them and applies no matter which one you're in, whether you're in records, assessments, disclosures, and that'll be on this slide. And that is, think in terms of authority. First question you want to always ask yourself is the source. What document or statute is giving the board the power to do this thing? Okay. The second is procedure. Did the board follow the required procedures that are set out in the statute? Or did they diverge from that and act on their own? Third is conflict. Does the action conflict with a higher legal authority? And in the next coming slides, we'll talk about what that authority is and what the statutory basis is. And then is, what's the standard? Is it a reasonableness standard, good faith, or are there higher standards that are more due process oriented? Okay. Run every dispute that your client is having with their HOA through those four in this order: source, procedure, conflict, standard, and it'll tell you fast whether you've got a case and where the board's exposure is. Now, Davis-Stirling Act, specifically 4205 of the Civil Code, lays out the hierarchy of governing authority when it comes to HOAs in California. So it basically states on top as the governing authority in this order, federal, state, and local law. So obviously Davis-Stirling Act is the California statute that controls, but to the extent there's a federal law that governs the field, then that's going to trump any California law. And that doesn't happen a lot because most of California laws are actually stricter than the federal version when it comes to HOAs. For example, all the discrimination laws and the accommodation laws that are found in federal law are stricter in California and stricter in the Davis-Stirling Act. So you actually don't run into that problem a lot where federal law will trump the Davis-Stirling Act. But we do run into issues where Davis-Stirling Act needs to trump local law. That happens all the time. So federal, state, and local law trumps everything. And then right underneath that are the recorded CC&Rs, the covenants. Okay. And underneath that, you have your articles of incorporation, which for 98% of the cases in California, they're completely irrelevant. So you're almost never going to have to look at an articles and make any sort of decision because they're almost universally completely irrelevant. To the the extent you get that 1 in 100, where the articles say something that is conflicted with by something lower, articles would control. But CC&R sit on top of that. Underneath the articles, you have the bylaws. Now, the bylaws, I like to compare to the rule book that a baseball umpire is reading to decide whether or not that's an infield fly rule or not. It's the rules about how that board is supposed to govern itself. So all the stuff about meetings, all the stuff about selecting a new board member, all the timing notices for elections, that's usually stuff you find in bylaws. It can be in CC&Rs, and often is, but the bylaws will almost always have it as well. And then underneath that, you have everything else. Operating rules, architectural guidelines. They're called different things. They have different names, but they're basically, these are the things that are either hinted at in an above document or they're covered, but these lower rules will flesh them out. Almost every HOA in California with more than 10 units is going to have some sort of set of operating rules. Sometimes they combine them with their architectural rules. Sometimes they're separate documents, but those are all equal at the bottom. And that's your hierarchy. If a rule conflicts with the CC&Rs, CC&Rs win. If a rule conflicts with the articles, unless it's conflicted by the CC&Rs, articles win, and so forth down the issue here. Now, here's a conflict. And I see most people don't ever spot this at this stage. A board can't enforce a rule, for example, that blocks solar panels or the construction of an ADU or drought-resistant landscaping because higher law controls. We'll get into some of that later. Those are governed by state law. So to the extent that an HOA CC&Rs or bylaws or operating rules try to limit what's governed by statute, they'll automatically lose. Even if it's in black and white in the recording documents. Now, a frequent abuse by bad HOAs is using an operating rule or a guideline in the architectural guidelines to accomplish something that legally requires an amendment to the CC&Rs. That was kind of what I was just getting into a second ago. So the board wants, a new substantive restriction. But it doesn't want the membership vote, which is usually on a supermajority to amend CC&Rs. It doesn't want to record an amendment because it doesn't think it's going to pass. So it does it through a lower form document, like a rule. I'll give you an example. Say the CC&Rs permits rentals with no minimum term. So you can have a short-term rental of 1 day, 2 days. You can put it on Airbnb. You can do any of that. The CC&Rs permits it either because it is silent on the issue or because it affirmatively gives that penalty. We've seen boards decide, you know what? Short-term rentals are just not good for our community. We want to ban them. We want to ban them to what state law allows, which is anything 30 days or lower, we want to ban. So they adopt an operating rule imposing a 30-day minimum. Okay, that's an easy one. That directly conflicts with CC&Rs. The rule's not enforceable. Homeowner doesn't have to follow it. Okay. We also see that, for example, where HOA in the CC&Rs has a rule that says that, let's say, sprinter vans are not permissible. Okay. And then the HOA decides, you know what? Sprinter vans are fine as long as they're not RV conversions. So they say sprinter vans are okay unless it's an RV conversion. No, because the CC&R said no sprinter vans. It didn't add any kind of a filter or exception to that. So you can't rewrite. And we see that happen a lot too. Okay. Rules, legitimately speaking, supposed to fill in details or handle things that were referenced in a higher document but not fleshed out. They often are used to clarify an existing right that's mentioned in the CC&Rs, for example, or set published standards on how to view that right. But they can't alter the substance of a right that's granted by a higher document. The test is always substance over the label. So as an attorney, if it's form over substance, it's probably not going to be legal. Now, we'll start with open meetings and transparency. The most important thing for HOAs at the very top, and in order for them to even work, is that there has to be transparency. In fact, there is a mini within the Davis-Stirling Act called the Open Meeting Act. And it's because of the incredible importance of transparency And that's why it's baked directly into a part of the Davis-Stirling Act. So the premise is pretty straightforward. Boards make consequential decisions that cost people money and affect people's rights to utilize their personal properties as they see fit. So, and they can do that because it's their job to make sure that money is being spent to maintain, replace and repair common area components, decide things like who to hire vendor-wise, and they have a lot of important decisions to make. Because those decisions matter and they affect everybody's life on a daily basis, transparency is extremely important. And so the Davis-Stirling Act helps facilitate that in 4 primary ways. Regulations regarding notice is the first way. Members are entitled, for example, to proper notice in advance of any open meetings. And meetings can include meetings of the board of directors where there's a quorum. Most HOAs in California have 5 board members. It's just probably, I would say 90%. So 3 would be a quorum. But even committees that are selected by the board that have power to make decisions and which are seated with at least 3 board members also have to keep minutes and provide notice and those sorts of things, just like everything else does. So notice is number 1. Okay. Homeowners are entitled to advance notice of any meeting. The second one is agendas. An open meeting requirement, or an open meeting requires an agenda. Okay. Any committee meeting, any open meeting that homeowners are allowed to attend, and any executive session meeting which homeowners aren't allowed to attend. But agendas have to be published in advance and they have to be given to all the homeowners. Okay. And that's obviously because the board's actions at those meetings are by law limited to the items that are listed on the agenda.
Michael, does an executive session regarding personnel matters or litigation have to have an agenda that's published to the members, or can that be kept only for the board members?
No, and I'll answer that. I'll first say that we are going to go specifically into executive session later on in this. But executive session, what can be discussed are the 6 items that we're going to talk about later. The agenda has to list generally the items to be discussed. So I'll give you an example. One of the more private things is, let's say, discipline on a specific member. The agenda wouldn't need to say hearing on whether or not to discipline John Smith for violating this rule. It could just say member discipline issue with 2 homeowners and leave it at that. It has to say that. Don't have to go into specifics. It's not supposed to betray any of the private material that's being covered, but it has to generally say it so we know, okay, there were 2 hearings. That's all that needs to be said. But yes, the agenda on executive session has to at least state that.
But you could simply say personnel matters and you don't need to name who it is.
No, that's right. You could say, I would go further. I would urge an HOA board to say, discussing whether or not to select a new landscaper and leave it at that. You don't have to mention anybody. Or discussing whether or not to hire a new handy person, but you don't have to give a name. Yes, your way would actually suffice for the law.
There's a question. There's no limitation on the number of executive board meetings that a board can hold, are there?
No, as long as the issues being addressed fall into the statute's 6 itemized. We're going to talk about the fact that the statute is actually problematic and puts the HOAs between a rock and a hard place. And I don't normally take that position, but that's an example of a badly written statute. But as long as it falls within the items that are allowed to be discussed in executive session, if those things come up and they need to have that kind of meeting a couple of days a week, then that's what's going to happen. There's no limit.
Thank you.
Yeah. So, and then of course we've got attendance, which is members allowed to attend and observe all open meetings. Again, meetings of executive session, and then minutes. Minutes must be kept, and the minutes must be finished, or at least a summary of the minutes must be finished within 30 days of every meeting. Now, a lot of HOAs don't do that. That's a technical violation. It happens all the time, but that's at least what the law says. Okay. The operative rule is that last line. Okay. Board business can't be conducted outside of a properly noticed open meeting unless it's in one of those exceptions that we just talked about, and that we'll talk about later.
Can a board take a vote between scheduled meetings, for example, by email or something, if they can't arrange to actually get a meeting together?
No. In fact, there's more recent case law on that. We're going to cover that as well later on in this presentation. I'm going to actually cover that specific issue as well. If a decision, and by the way, there's no case law on this. There's a little bit of case law on this. So part of this is my opinion, just based on my experience, which I think is pretty well developed, and it's probably pretty trustworthy. But the case law goes a little further than the statute. So the courts have interpreted the statute pretty broadly to allow some sort of discussion. And, you have these town halls that are permitted. What can't happen is there can't be a decision to act or not act, or even a decision to the later time, unless it's something to say, look, we'll make a decision during our open meeting on this. That you can say. But if you start to cross that line into, okay, how do we feel you want to go? Which direction we want to go? You're now in the decision-making category. You have violated the law.
If I might go back to the prior topic, I'm sorry, just for a moment, because we had a question that came in late and I had another comment. But
go ahead.
About the hierarchy of things. Just people obviously would hopefully realize that the CC&Rs are recorded, so you can get those as recorded documents. But when your client or somebody is buying something in a Davis-Stirling development, the bylaws are something that you need to get as part of a package. Most HOAs are going to charge some fee when the new owner comes in to give them the package that's required to be delivered, but you need to make certain you're getting that package, which also includes financial information that you'll want to look at on the association. And then the question that we had is, if a CC&R provision prohibiting obstruction of neighborhood views that indirectly leads to the inability to build an ADU in a backyard enforceable, and I'm in an HOA but we're not Davis-Stirling, and we have this problem all the time with view obstructions. But on a Davis-Stirling development, their question is, if it's view restricted in the CC&Rs, can that mean if your ADU is going to block views, you can't build it?
Okay, and that is a great question, and it's one of the ones that we've gotten before, and I've got an article on that somewhere on my website under the libraries tab. I've got a fact sheet on that issue. There's some case law, not a lot. There might be one or two cases, as I recall off the top of my head, that go into that. The public policy behind ADUs is very strong, and as a result, when there's a challenge between a specific view, and by the way, the CC&Rs would have to be a very specific view corridor, right? Like either by mathematical footage or angle. That is not going to trump ADU. So if there is a way to construct the ADU so it doesn't block a view that is protected under the governing documents, then an HOA can require that. But if there's no way to do it, if the property is situated such that the HOA, that there's no way to build a compliant ADU on the property without blocking that view, the ADU is going to trump. That's at least the way it looks like the courts are going right now. And that's that creates some difficulties when it happens, but we've actually seen that happen very few times. We consult 30 to 50 new clients a week, might be probably closer to 50 clients a week. And I can count on one hand the last couple of years that issue has come up. Now, view stuff comes up all the time, but not in terms of an ADU.
Thank you.
Yeah, I think I answered. I think that's the best I can give right now. So so we just kind of talked about the Open Meeting Act. Now let's talk about the fact that the label isn't what's important. Again, for the most part, the Davis-Stirling Act is written in plain English. And it does a relatively good job of passing a message on that it's really form over substance. So, if you got a gathering of a quorum of directors, so if you got if you got 3 directors meeting at the pool or talking on an email, and they are deliberating about HOA related business or making decisions, it's a board meeting. And it doesn't matter if they call it a planning session or a town hall or a workshop or an informal meeting or an email chain. We see that all the time. It's the deliberating or making decisions on substantive HOA related business that makes it a meeting, no matter what they call it. So if they're calling it a town hall and it's really not, it's going further, then they've violated the notice, the agenda, the member attendance rights, and the minutes requirement. That's what gets HOAs in trouble. There's a nuance though, and you got to be precise. The statutes list hear, discuss, or deliberate. This is what I was talking about a second ago. If you look at Civil Code 4090, in the definition section, the key point for your practices is that it defines board meeting very functionally by what the directors are doing, not by what they're calling it. So that label is less important than the substance. Looking at the statute itself, it uses those words. It uses, if it's deciding, deliberating, or hearing, or discussing, okay? A genuinely informational gathering, like where members ask questions and the board gives updates. Let's say there's a major construction event that's going to be occurring throughout the community. New roofs are going on. There might be a town hall where the board, sits in front, meets in the green area somewhere and answers questions that are being peppered to them by the homeowners. And hey, what's the status here? What's going on? Well, we hired this guy and this company's starting soon. And none of those don't require any deliberation or decisions. It's purely informational. Those are true town hall meetings. Those aren't open meetings. You don't have to abide by anything because they're not deliberating or hearing anything. But when you get a gathering where they cross into deliberation or where they actually vote and make a decision, now you've crossed that line, and it requires the different elements that we talked about in the prior slide. The notice, the right for homeowners to attend, an agenda in advance, and the minutes. You'll find these obligations, by the way, for the most part, we're talking about the Davis-Stirling Act today, but some of this is also found in the Corporations Code because 99% of the HOAs in California are mutual benefit nonprofit corporations. The Corporations Code is often going to be important, and it's going to control. If there's a conflict, by the way, between something in the Corporations Code, we find this a couple of times, and the Davis-Stirling Act relating to HOA matter, Davis-Stirling Act will control over the Corporations Code. So members' right to speak is a big issue that comes up a lot more than you might think. Civil Code 4925 and 4930 gives members the right to speak at a board meeting. And for those of you who live in HOAs, you've known this under different names. A lot of them call it the open forum or open floor session. And this is where, and it's often at the beginning of a meeting where they give homeowners, let's say, a minute or two to say something. Okay? That is required. Now, HOAs can control the timing on that. They have to allow a reasonable amount of time, and courts have kind of held that 2 minutes is reasonable. Okay? So they have to allow sufficient time, but they have to have that session, whether it's at the beginning or the end of a meeting, they've got to have that open forum. Okay? 4925 gives members a set amount of time to speak on matters related. So what does that mean, matters related? Because a lot of boards, this is where a lot of bad HOA boards will use this statute to ban somebody from speaking because it's not on the agenda. Okay? A board can set reasonable time limits, as I said, and they can enforce basic rules of decorum. Using foul language, interrupting other people, being threatening, that sort of thing. They can shut you down for that. Okay, that makes sense. What they can't do is shout somebody down or mute them because they're speaking about things that are not on the agenda. And this is in 4930. It's crystal clear. Agendas are for boards, not for members. So during open forum, members are not limited to items on the agenda. They can speak about any topic they want as long as it's related in some way to the HOA or life in an HOA. And that's almost carte blanche, to be honest. And we see this abuse all the time. You have people either, if you're attending on Zoom, they shut your Zoom off or they mute you, or they will mute your microphone if they don't like what you're talking about. If you're calling out board members for, committing all sorts of wrongs, from gross negligence to embezzlement or fraud, they'll often shut you down. They can't do that. That's illegal. If you have a client that comes to you and they get gavelled down or silenced for raising issues with the assessments or elections or the unfairness of it, and they're shut down, there's a weapon right there that you've got, that the board's actually violated the law, and specifically 4930. Now, let's talk about those 6 topics in executive session. And I'll also talk partly about the problem, that a very real problem that exists. First of all, courts have said executive session is an exhaustive list. It's not a catch-all. So that means that you can only discuss the things that are referenced in the statute. So Civil Code 4935 is the executive session statute. It's the only one. The single most important thing to understand about it is that this is it. There are 6 things that are listed here. And that leaves a major problem. But let's first talk about those things. So 1, it's litigation, pending or anticipated litigation, or current litigation. Okay, that's pretty broad. Anything related to litigation or the threat of litigation can be discussed in executive session. Second one is third-party contracts. So that's whether it's contract with a vendor, contracts with a management company, contracts with a handy person, contracts with landscapers, whatever contract that the HOA might need to enter with any third party is allowed to be done in executive session. Third is member discipline. Now, this is actually up to the homeowner. Technically, the statute says that if the homeowner's request, this should be done in executive session, which implies pretty strongly that if a homeowner never requests it, it can be done in an open meeting. Except most HOAs just protect themselves, automatically have it in executive session, and automatically do it in private, in a private hearing, and that's permissible. Personnel matters is number 4. And that's people that actually work for you that are employed as either W-2 or 1099. But really, it's for the W-2 employees. And depending on the size of your HOA, some HOAs, a lot of smaller HOAs don't have any full-time employees. But the bigger ones will have their own group of landscapers. Instead of farming it out, they'll have their own people, or they'll have one or 2 handy people. That's what personnel matters. So we're talking about employee issues. And of course, that's going to be private. And then payment plans. Somebody's running, you got a homeowner that's running into a problem keeping up with either their regular monthly dues, their assessment, or they're having trouble paying a special assessment and they reach some sort of agreement, get on a payment plan. That has to be done in private and therefore is acceptable in executive session. And the last one is if the board has to decide whether or not to pursue foreclosure against somebody that hasn't paid an assessment, that has to be done in private and therefore needs to be discussed in executive session. Now, that's it. If you go to some of the larger HOA side law firms, including the biggest one in California, and you look at their website and you look at their articles on executive session, they add a lot of stuff to this list, and that is illegal. And that's a problem because guess what? In many cases, the HOAs are right. But the problem is the statute says what it says. And because of that, until they amend that statute or the court, makes a decision and says, we're going to expand the reading, it's actually illegal. I'll give you a great example. It doesn't fall into these. They absolutely should be private. And that is you have a homeowner who wants to go to the board to seek, they've got some sort of disability and they want to seek an accommodation. So you have a homeowner with mobility issues and they want to have a red curb area right by their house. Painted white for them or painted a different color so they can use it, a handicap zone so they can use it as a parking area. That shouldn't be public. That should be private. And yet it doesn't fall under any of these. Now, it could. You had a homeowner that was disabled start parking in a place that wasn't legal, and they sent a hearing notice out. And at the hearing, member discipline, they reached an agreement. Then it would be covered there, but only because of that member discipline aspect. But a homeowner doing the right thing and trying to go into the interactive process that's required by state and federal law would be of luck if they follow the statute directly, because there's no mechanism for this to be private, and it should be. It's not anybody else's business what disability somebody has and what accommodations they're asking for. And yet you have a huge gap in the law. So I've written on this, and we've actually trying to work with our legislature to try to get an amendment to 4935 to open up that list a little bit more because it helps homeowners. I represent homeowners, and if I represent a disabled homeowner, I want that homeowner to be comfortable asking for an accommodation without having to worry about whether or not this is going to become public record for the community. So,
Michael, We did have a question as to whether an HOA member can have access to committee meetings.
Okay, in the committee meeting, there is a quorum of directors. That is, they have power to, then yes. If, however, you have one or two directors and then you just have members at large and they have to report to the board, then no, you don't.
What about an architectural committee meeting?
Same guideline. I've got an article right on point on my website on that. It's the same rule. Okay. If the architectural committee is composed of 3 or more directors, then they can make architectural decisions without going to the board at large. If they can do that, then they are the board because it's a quorum, or at least a quorum acting, and therefore it's subject to the Open Meeting Act. If it's the president of the board and then some homeowners at large, then nothing they do can be definitive. They make a recommendation, and it might be a rubber stamp, but at least technically they got to go to the board and let the board decide. Then you would not need to follow the Open Meeting Act.
What if the architectural committee makes the decision initially, but there's a right of an appeal to the board?
No, that's a meeting because there's already a right of appeal built into the statute. That already exists.
Okay.
So
just to let you know, we're at 40 minutes.
Okay, I'm going to speed up a lot then. Let's talk about records and enforcement. I am going to go much quicker because I do want to allow for question and answer as well. And all of the stuff that I'm talking about in here, I've included in the handout a 6,000 word article that I wrote that goes through this in even more detail, that goes through the entire Davis-Stirling Act. So you'll find all this in that. But basically, when we talk about 5,200, we're talking about 5,200 FSEC, which is anywhere from 5,200 through 5325, let's say. And homeowners have an incredibly broad right to a lot of documents. Basically, if the HOA is spending money from a homeowner, spending homeowner money to do or make decisions, then the clients are going to, or the members are going to have a right to see that document. So it includes, not only the traditional financial stuff like bank statements and copies of checks and ledgers and invoices and taxes and all that, but also all of the governing documents, election materials, reserve materials, the Balcony Inspection Act, even attorney-client fee agreement, which is normally privileged, but that document is not privileged. It's specifically permitted under the 5,200 documents. It's actually quite broad. So if you've never looked at that statute, I recommend you look at it because it's homeowners can really get a lot of documents. And there are some real teeth. A board that will not give documents that they are obligated to give to a homeowner can get $500 in sanctions per category of document they request and a one-way statute for attorney's fees and costs. And so we bet this is one we do all the time, and we've gotten, our typical 5,200 demand will include anywhere from 15 to 20 categories of documents. Well, let's say you're asking for around 20 categories of documents at $500 a piece. You're over 10,000 in sanctions alone, never mind attorney's fees. So there is a very, very strong fee shifting aspect to the 5,200 right, and it is a powerful right. And it's these documents that allow homeowners to the best of their ability, figure out what's going on with their HOA. Stuff that should be in there that aren't, or things that don't make sense or that are conflicting with prior things, or will give people evidence that, hey, we might have an investment problem. We might have a gross negligence problem. And the statutory deadlines, there's 3 that you got to know about, and it's very easy. 5 days, 10 days, and 30 days. Okay, 5 days, the membership list. And by the way, membership list is the only one of all the documents that you're entitled to see as a homeowner. It's the only one that they can require you to have a legitimate reason for. And it's a very, very broad reason. It's basically any legitimate reason that relates to the business of the HOA. They can make you state that. Every other document, you can want it because you want it. And it doesn't matter why. They have no say. So that's got to be done in 5 minutes. And by the way, that includes email addresses, phone numbers, names, and property addresses. And the only exception is if a homeowner has opted out in writing, then a homeowner can opt out of having their name disclosed or their address or all of their information. But other than that, and that almost never happens, you have a right to see the name of everybody, where they live, their emails, all of that. So that's 5 days. 10 days, basically current financials. And then 30 days is everything else. That's it. We talked about the fee shifting already. I did that in the last in the last, once I can skip that. Now let's move into elections. Okay, so elections are governed by 5100 to 5145. Elections are not just electing a director, but whether or not the CC&Rs need to be amended, whether or not a special assessment of over 5% of the budgeted expenses for that year, because that requires homeowner a vote. That's what I mean by election. Elections in HOA are done by secret ballot. They require selection of either 1 or 3 independent inspectors, and all of them must give equal access to candidates and board members. So if there's a Facebook that is operated by the HOA and a board member that's running for election, let's say, is talking about him or herself, then they've got to open it up to all the candidates equal. Same with use of the clubhouse or any other amenities. So the bottom line on elections in HOAs is they must be fair, they must be impartial, they must be secret, and homeowners that want to fight an unfair election or something that's been done illegally, they have a year to do it, and they can do it in small claims court and they can do it in superior court. Okay, 5110, for example, is the process that requires the independent inspector. What makes them independent? Well, it can't be a board member. It can't be anybody that's running for the board. It can't be a family member of anybody running for the board. It can't be anyone that's under a contract with the HOA. For example, so many HOAs select their management company or somebody from the management company to be an inspector. It's completely illegal because management companies are under contract. But yet you see it every day. Can't do that. It's got to be completely independent. So they have to be 18 or older, and they've got to be completely independent. It can be a homeowner that's not running, but that homeowner better understand the legal duties. So a lot of HOAs, especially well-run ones, use professional management companies that run, or professional inspector companies that do only this. Especially now that we've got electronic voting, if your HOA goes that way, you want somebody that understands all the ins and outs of how to run those electronic voting machines or the electronic voting algorithms. You need somebody that knows that because it is complicated.
I once overturned an election at a 2-tower development on Ocean Avenue in Santa Monica where somebody acting as inspector of election walked around to the other side of the table to turn in a bunch of proxies, and they put up a new slate that got elected supposedly at that election. And
was that the judge threw it out. White buildings right on the ocean near the pier?
I'm sorry, this was 515 Ocean Avenue.
Okay, I think I think I know which buildings are on. We've litigated against that HOA on several occasions. That HOA has had a monumental history of being very badly run. So I'm not surprised to hear that. But great comment. Thank you on that. Let's talk about manipulation and how to challenge it, because you see, and this is what Howard was just talking about. Bad HOAs they manipulate elections in a variety of ways. Okay, the tactics that I've got listed here, the incumbent protection playbook used by bad HOAs all over the place. So nomination notices, for example, that go out late or not at all, or candidates get disqualified or invented or on pretextual grounds, in violation of the statute, or unequal access to association media. We see that a lot with Facebook or HOA owned or HOA managed websites. We see that a lot, where the board slate gets the newsletter and the challengers get nothing. Board slate gets to utilize all these tools and the challengers get nothing. That's illegal. Or misuse of HOA resources to campaign for incumbents. Here's a big one: last minute rule changes or last minute change in the slate. You can't do that. Okay. When you stack a couple of these together, you get really bad results and turnout in votes. So if it's a bad HOA that's trying to engineer the election, it's very obvious what they're doing and it's easy to spot. That's the good thing. So under 5145, a member can challenge the election in court, and relief is very broad. And courts can, including small claims, which is not the norm, they can order compliance, they can order injunctive relief, they can invalidate results, they can require that procedures be corrected, they can require a new election, they can impose statutory penalties, they can award attorney's fees. Again, one-way statute. Even if the homeowner wins and they prove that if the HOA wins and they prove that the homeowner's case was frivolous, they still only get their costs. They don't get fees. So it's very powerful fee shifting on this. So Davis-Stirling Act is very clear. Do not mess with elections. Yes, Howard.
Yeah, they may order that new election under the auspices of, for example, a retired judge, which they did in my case, and that in order to make certain that things are fair. And there was a question that if you don't have an independent inspector of election, what's the remedy? And I think that's the remedy. Then you go in to have the election overturned and a new election.
Terminated. So here's what courts have said on when to overturn an election, but not having an inspector is enough by itself. If the thing that was done wrong would have reasonably made a difference in the outcome, then they will throw the whole election out. If it's a de minimis issue and it wouldn't have made a difference in the end result, then a court's going to be a lot less likely to throw the entire election out. But if you don't have an inspector, that election's done, because the inspector is the only one that's allowed to have custody of or access to any of the ballots, and the only one that's allowed to open the ballots and put them in the little hoppers for the count. You cannot have board members storing ballots in the garage. You can't have ballots being received by the management company and then sent to the inspector. Can't do any of that. If you don't have an inspector, you've just multiplied the wrongs there. So your election is over before it even started, if that's the case. You don't see that a lot anymore, but to the extent you did, it'd be a slam dunk. Over.
Thanks. That's a great clarification. Thank you.
So next is discipline, disputes, and money. And discipline is the big one, because I'm sure the lawyers that are sitting on here have all heard about AB 130. It went into effect mid-year last year, and it is one of these. It took an issue that absolutely needed to be addressed in litigation, but it is such a stupid law. It was passed as a last-minute amendment on an ombudsman. I always have trouble with this word, ombudsman budgetary bill. It sailed through committee. It left a whole host of unintended consequences out that have made it a complete mess that we are now seeing come to fruition. I've made a bunch of predictions the week that it came out, that went into effect, and all the predictions I made a year ago are coming through now. It did do certain things that were good. And one of the most famous thing it did is it said, guess what, guys? $100 cap on all fines for violation of a rule. So all those fine schedules that had escalating fines, illegal, gone. Okay. So let's talk about AB 130 in general first. AB 130 affected a lot of different statutes, by the way, including the ADU statute and the solar statutes. But it's big. The most affected was on two parts of the Civil Code in the Davis-Stirling Act, 5850 and 5855. And those govern discipline. And there are 4 requirements. If you miss any of them, you being the HOA, were to miss any of these, it's fatal to the discipline. So there has to be a published fine schedule, and the fine schedule has to have the fines legally stated. It's got to get rid of anything over 100. Okay. If there's no privilege, if there's no a published fine schedule, no discipline. You can't. You can discipline. You can. I guess you could say naughty, or you could maybe suspend rights, but you cannot fine. That part would be illegal. 2, notice under 5855. 10-day notice. If you're going to set a hearing, you got to give at least 10 days before the hearing date. You got to state the violation. Here's what you did wrong. Here's what we're thinking of doing to you. Here's your hearing date. Here's the time. See you then. And then, of course, you have to have that hearing, and a member is permitted to appear, whether by Zoom or in person is up to the people deciding. It's not important, but they have a right to appear and, more importantly, respond to anything that's being, to any of the allegations that have been set forth against them, and to introduce evidence, to, provide pictures or statements from other homeowners, anything that they feel will help their case. The hearing should be held in executive session, and homeowners have an absolute legal right to bring an attorney. Now, the HOA does too, but homeowners do. And then the HOA must, at termination of the hearing within 14 days, give a written decision and send it out to the homeowner. Okay? Those have to be required. If any of those are skipped, then you're done as a board. You skip notice, you skip the hearing, or you rubber stamp the outcome, miss that 14-day deadline, discipline fails. So this is a great little checklist for a client. You look to these. No fine schedule, done. 10-day notice, done, etc. Now, here's the discipline regime. It capped per violation at $100. So you can never have a bigger fine than that. And then you get a lot of HOAs that go, oh, okay, here's what we're going to do. We're going to do something called stacking. We're going to send you a hearing letter on Monday for this illegal whatever. And then we're going to send you another one on Tuesday, another one on Wednesday, another one on Thursday, and we're going to set different hearings, and we're going to fine you $100 per. That won't work. It's all one violation. Won't work. Now, I won't get into it in this, but I do get into it in the article. That's one of the big problems that AB 130 created, because it incentivizes homeowners to say, you know what, that's the cost of doing business. I'm going to build this illegal balcony, and then I'm just going to take the fine. So it's forcing HOAs into skipping fining and going right to a lawsuit to enforce governing documents, which is more expensive for everybody and is a mess. And we're seeing it happen right now. But $100 limit, no interest or late fees on discipline or on fines. Basically, for discipline money, if they don't pay, you don't get interest, you don't get late fees. There's now cure rights that are built into 5850 and 5855. For example, if they notice a hearing because I have something hanging in the common area I'm not supposed to have, and my hearing is set for 10 days later, and between the time of the notice and the hearing, I fix the issue. I take care of it. The hearing must go off calendar. There can be no hearing and there can be no fine. It just must be, oh, thank you, you're done. Okay, we're good. That's it. You have a right to post-hearing or during hearing a IDR, internal dispute resolution. Again, that's a homeowner right, not an HOA right. And then you can actually enter into agreements. This isn't new. This existed in the former statute, but it was refined a little bit. You can enter into enforceable agreements at the hearing that are enforceable in court. So the 5 things to remember basically are, AB 130 did a lot of things, but it limited to $500. It banned interest and late fees. It provided cure rights. It gave rights to post-hearing IDR, and it tightened up the enforceable hearing agreement that could be reached during the hearing. Now, there's 2 pre-litigation tools that are important in HOA law. One of them is IDR, 5900 to 5915, and the other one is ADR. I'm going to be very brief about this. ADR is completely voluntary on the part of the homeowner. No matter what governing documents say, there are a lot of governing documents out there that say before you can engage in ADR or file a lawsuit, you must engage in IDR. Those are void as a matter of law. Okay? IDR is mandatory if a homeowner requests it. And all that means is that at least one member of the board is agreed to sit down with the homeowner and try to work out their dispute informally. Both sides can have their lawyers there at their own expense, but nothing, it's just sitting down with the other side and trying to talk it out. Okay? In my experience, unless you have a board that is just mistaken in good faith on something and you just need to clear it up, in which case IDR is a good idea, it's usually a waste of time. If you're dealing with egos, if you're dealing with bad feelings or the hatred that we see between certain homeowners and their board, IDR is always a waste of time. HOAs can't require it, but they must agree to it. And if they don't, they get in a lot of trouble. ADR is a little different. If you are bringing a claim for injunctive declaratory writ relief, you are bringing one of those claims in conjunction with money damages of less than $12,500, i.e. small claims court. You must engage in ADR before you can file a lawsuit. That goes for both sides. And in the context of the Davis-Stirling Act, ADR means mediation. In all the other cases, it's not required. And in most cases, if you have damages, if you're going to have damages, actual money damages are going to be more than $12,500. So it's almost never actually required unless seeking injunctive writ and or declaratory relief. So I would say we push most people into ADR, but in most cases, it's not technically required. But all the cases where it's required, you must engage in that, because if you don't, the other side calls you out. They can demur. That demur is going to get sustained with leave to amend, but it will be sustained. More importantly, there's a consequence for failing to abide by an ADR demand when it is required. And here's where we nail a lot of HOAs. If an HOA, for example, refuses an ADR demand, and they end up, this case goes to trial, and the HOA ends up prevailing, the judge can take their refusal to engage an ADR into account in deciding on whether or not to award them attorney's fees. And let's say they have 150 grand in attorney's fees. A judge, we've seen judges say, well, and these are, we've never lost, knock on wood, we've never lost in court. But we've seen this happen where judges have said, well, HOA, I'm going to give you 10,000 because you could have resolved this at ADR, tried, and you rejected it and forced them to go through this. Judges can do that. And so there's because of that, very few HOAs nowadays refuse a valid ADR demand. Now, let's go to 4765, perhaps one of the most important statutes in the Davis-Stirling Act, because that's where the architectural control is found. So architectural authority on an HOA is broad, but it's not a personal taste type of authority, okay? Its entire purpose is to anchor in principle that an HOA has a reasonable right to make good faith requirements or good faith decisions on things that will affect the aesthetic of the neighborhood. Okay, CC&Rs that if they can ban something that is, let's say, not harmonious, but there has to be a good faith basis for it. Decisions by an architectural committee or by a board can't be arbitrary, they can't be capricious. If they are grounded in a limitation set forth in one of the governing documents, CC&Rs or rules, and it's applied evenly, there's no selective enforcement, and it's not arbitrary and not capricious, if it's reasonable, then it's going to be upheld as a power to limit, okay? But there has to be a written standard, there has to be written reasons, and that's the thing. If you get denied, the HOA has to tell you why you were denied. They're supposed to tell you what you're trying to get, what this fence or this balcony is violating this section of the CC&Rs. Here's what you need to do to fix it. That's what they're supposed to do. Okay? So you ask yourself, what do you demand in a denial? It's got to state the written standard that's being relied on. It's got to have a written reason. The version of the guideline being applied, the decision makers' names, the people on the board or committee that voted a certain way, and then comparable approval showing how similar requests were treated. You can demand that. Okay. Always make sure the HOA provides a written description of all of them. And I make that demand in writing on behalf of a client. And if an HOA says no, I can't force them on a couple of those. I can't force it. But boy, does that look bad to a court. Now, there are certain things that have, and we talked at the beginning about these statutorily protected rights that HOAs have very little to no discretionary powers. And the big six are solar energy, ADUs, alternative dwelling units, like granny flats, that sort of thing, drought-resistant landscaping, flags and clotheslines, satellite dishes, and EV charging. The public policy behind each of those are powerful. And this slide is a good example of a hard outer limit on architectural control, because California law very strongly overpowers and overrides authority by HOAs when it comes to these things. So, for example, let's talk about solar energy systems. The code basically says, it's 714 and 714.1. The code basically says, if an HOA can prevent you from installing solar panels if it's going to somehow affect somebody else's rights, or it's going to create a health and safety issue somehow. And nowadays, with technology being the way it is, that's coming less and less. There used to be some fire hazards with really cheap materials, but you don't see that anymore. So solar energy systems, the law basically says, hey, HOA, if what you're demanding of the homeowner is going to lower the energy capacity by 10%, so that maybe the amount of wattage that this thing can save by 20 or 10%, or increases the cost of this solar energy system by $1,000 or more, you have no say. That is very powerful, because pretty much every solar company out there has dealt with HOAs. There's 60,000 in California alone. So they know exactly how to position these things, these applications. They take care of it for you. And they almost make it impossible for an HOA to do anything. In fact, it's such a powerful system, or such a powerful policy, that even condo owners with a shared roof, think about this, they have a right to solar panels. In almost every other case, HOAs have an almost godlike universal power over common area. They could shut you down on the common area whenever they want. But when it comes to solar energy, even condo owners have a statutory right to put solar panels on their pro rata portion of the roof. And as long as their panels don't block somebody else's light or interfere with somebody else's, then the HOA can't do a damn thing about it. And that is a very powerful right. We're talking common area. I'm going to go up on the common area roof and I want to install solar panels on my pro rata portion. They can't stop it. That's how powerful this one is. And the same with all these other issues. And I've got articles on all of these on my website if you want to go look at those to get details. Assessments and collections. Let me start with the obvious. This is controlled, by the way, primarily by 5600, 5605, and 5615. And there are two kinds of assessments. The first kind is the general dues, the amount of money that you pay, that everybody pays their HOA every month or every quarter, depending on how your HOA works. That's the normal dues that are repeated. Those are just your general, you want to be part of the HOA, you got to pay this every month or every quarter. Those are general dues. Those are called general assessments. Then there's special assessments. Those are one-time charges to pay for a specific thing, whatever that is. When it comes to, and by the way, assessments does not include fines for discipline. That's important. But when it comes to assessments, we have one rule, and one rule only. We tell everybody. And it's because there's no right time set in California. Davis-Stirling Act does not recognize that. And a lot of people will say, look, I know for a fact that this special assessment they're trying to pass is way, way more than the 5% limit set forth in the code, and I'm not going to pay it because it's illegal. Homeowners can't do that. So we tell everybody that comes to us, if they've been withholding an assessment, hey, you want to earn your money as a lawyer? You tell them, pay the assessment and then challenge it. You don't waive anything by paying. You don't waive a damn thing. There's no such thing as a waiver. If you don't even have to write on the check, paying under protest. You don't have to do it. Tell them to pay and then go after the HOA. You'll always get that back. HOA has assets. They always have insurance and they have assets. You'll get it back. Never run into a situation where HOA couldn't pay when they had an attorney's fees clause or any fines levied against them or penalties by the court. So 5600 requires HOAs to collect enough money to do what they're obligated to do. Whatever it costs to run that HOA, to maintain, repair, and replace common areas, and do all the things that the CC&Rs require them to do, they have to get enough money to do it. They aren't supposed to collect more. They have to collect the amount it costs to do what they're supposed to do. Put some in reserve, which we'll talk about in a second. Okay? So that's 5600. That's an HOA obligation. We have to collect money from you. Okay? Then there's limits. Those limits are found in 5605 and 5615. And 5605 restricts increases above statutory thresholds. So general assessments, an HOA without a member vote can raise 20% from the last year's assessment. So if you're paying $300 a month for your HOA, then the HOA the next year without a member vote can raise that to $360. But if they want to go $1 above that, they got to take it to the members in a secret election with all the stuff we talked about before. When it comes to special assessments, they can a board can unilaterally pass a special assessment if it's less than 5% of the budgeted gross expenses from that year's budget. And there is an exception. I'll get to it in an emergency. We'll get to that in a minute. But absent a real emergency, that's their limit. Anything more than that goes to the homeowners. And that doesn't mean it's per assessment. That's for the year. So if you have more than one special assessment, they can't like break it up so they're all smaller than 5%. It doesn't work that way. Okay? Now, again, if you remember nothing else about this entire presentation, pay first, challenge later. Never withhold an assessment. Let's talk about reserve studies and the balcony law and reserves, because that is a very big part of this. So California HOAs are required to conduct a reserve study, full reserve study every 3 years. And of course, they're required to give a summary of that reserve study every year as part of their annual mandatory disclosures. And you find the mandatory disclosures in which I'll talk about that in the next slide briefly. But the reserve studies are governed by 5550. So what is a reserve study? It's a visual inspection of all major common area components. The trees, the roads, the fences, the clubhouse, the pool, the jacuzzi, the garages, the roof, if you're in a condo, whatever the HOA owns and maintains has to be noted as a line item in the reserve study. And a big important part of the reserve study is this number, this percent number that's always given in a percentage, and it's the percent funded number. So what is this reserve study supposed to do? It's supposed to tell you, okay, for this component, this thing has, let's say it's a roof. The roof on each of the condo buildings has a useful life of X amount of years. Roofs are 25 to 30 years nowadays, right? So it's a useful life of 25 to 30 years. Here's what year we're in now. We're in year 2 or 3 or 20, whatever it is. Here's how many years left based on that useful life. And here's how much, based on today's dollars, we think it will cost to, when it comes time at the end of that life, to replace that component. So we will rip this roof off, put a new roof on. How much is that going to cost? Now, since boards can't see the future and can't see what inflation and the cost of supplies, because nobody could foresee COVID, let's say, you might not know in 20 years what it will cost. So, of course, you got to do with, okay, what will it cost today? Okay? So here's the important thing. All that has to be listed on that for every line item. The percent funded number is the percent that says, okay, if everything that was coming due this year, everything that needed to be replaced this year was coming through, what percent of the amount of money it would take to do all that do we have ready to go? That's your percent funded. So there's a rule of I like to use, and it's different than there's a federal it's an advisory agency out there that's kind of governed by the people in this industry. So it's not government related at all, and it has no force of law. They issue an opinion every year, and I think they're way too generous. I go with the more conservative Michael Kushner one, which is if your HOA is anywhere in the 80%, you are stellar. You are in great shape. I've never seen an HOA above 84% in my entire career as a percent funded. Never seen it. Okay? If you're anywhere in the 70s, you're good. You're good. Good stuff. If you're between 65 and 70%, pay attention, but I wouldn't worry. 60 to 65, I'm a little worried, and I'm starting to pay close attention. Anything from 55 to 59, I'm very worried, and I'm looking, and I'm asking questions, and I'm looking at documents, but anything below 55, it's an emergency. You are guaranteed at some point down the way, your homeowners are going to be paying a special assessment to fix something major or to fund the reserves. Something's going to happen, and it's going to be bad. What has triggered this now is the balcony law, which you find in 5551. Because the balcony law, contrary to what you might have read online by some so-called experts that should have known better, balcony law had a requirement that all HOAs need to do their initial balcony inspections, SB 326, no later than January 1st, 2025, not 2026, which has been bandied around. To the extent they haven't done that, they're already in violation. And this came because of a disaster that occurred in Berkeley in 2015 when a balcony collapsed and killed 6 students and severely injured 13 other people. You have these components that are partly made of wood, or that are these cantilevered balconies, for example, that are decks or stairways or walkways that are either entirely or partly made of wood. And you know, as well as I do, that almost all California construction has wood in its undercore. So it's pretty much anything, okay? Those are things that are part of this balcony law. Every 9 years, there has to be an inspection by only 1 or 2 people can do it. A licensed architect or a civil or structural engineer, period. That's it. They've got to come and they've got to do a percentage sample in close-up, eyes-on inspection of every component that fits into the law. So all those balconies, decks, exterior elevated elements is what we call them, okay, have to be looked at. And if this inspector sees something concerning, they have to do some destructive testing as well. Then they have to issue a report. And if you're one of those HOAs that ignores that report because it's going to be a $20 million fix and somebody dies, you are in big trouble, okay? We've got video. I talk about this on my podcast. We have video of 2 kids moving an entire stairway, an exterior staircase back and forth. You could see the stucco on the outside of the building buckling and cracking. These kids were doing it, just 2 kids on their own weight. That should have been a red tag. That thing completely failed. If that thing is not replaced immediately,
We should move along a little bit, Michael.
all right, I'll go faster. Now, mandatory annual disclosures are required every year. There are 2 kinds. There are financial disclosures that are governed by 5300, and then policy statements, the discipline policy, the fining structure, all that has to be set forth. That's also where they provide a summary of the reserve study, and the percent funded number must be on that. You'll find that in the annual budget report. Okay, takeaways from this entire thing. If you're going to take away anything, authority is the first place you start. What's the source, procedure, the conflict, and the standard? So run every dispute through those. Second one is the law sits in this hierarchy. Under 4205, you've got laws, then you've got your CC&Rs, then your articles, your bylaws, and then all the different kinds of rules that exist underneath. 3, procedure, acts leverage, open meetings, records deadlines, disciplinary due process. They create defenses, and there are powerful fee-shifting statutes that even that playing field for homeowners. Number 4, records. Always get them. You have a right to them under 5200. Your client has a right to them. It's easy to get, and there are significant penalties and fee shifting for failures to do that. And then, of course, when it comes to assessments, pay, then fight. I'll say one other thing because I didn't mention it, and that is, well, no, I won't. I was going to cover the emergency exception to the assessment, so you can find that on my website in any article. And that pretty much runs us through the end.
Yeah.
And
Michael, so we have a ton of questions, most of which we're not going to be able to reach, and some are very specific. I encourage people to send those to Michael by email afterwards. There are 1 or 2 things that I'd like to hit real quickly,
Sure.
which is one question that I think is real important here is, when is an HOA not covered by Davis-Stirling?
Okay. I'll give you a great example because it's the most common. When it comes to manufactured housing, those are, people might know those as people that live in trailer parks. Okay. When it comes to manufactured housing, they can choose whether or not to be governed by the Manufactured Housing Act, right? There's a separate act that is much less robust than the Davis-Stirling, or they can be governed by the Davis-Stirling Act. But if an HOA, if they've recorded a set of CC&Rs, they're on a common area, then they're going to be a common interest development. They're going to have to abide by Davis-Stirling. In California, we don't have co-ops as much as other states. Back east, there's co-ops all over. Co-ops can also have a choice. You have very few of those here, but co-ops are one where you can go either way and decide. But for the most part, because we don't have those, those apartment conversions, condos, townhomes, single-family homes, there's an HOA. If there's a set of CC&Rs, if there's common area, you have to be subject to Davis-Stirling.
So one of the things for people to take away, because I'm dealing with one of these, is if there's no common area, you're not Davis-Stirling.
If there's no common area, you're not. There's no HOA. You don't fall under Davis-Stirling Act. Davis-Stirling Act requires property that's owned by the individuals in conjunction with common area. So there has to be at least some bushes, something.
Well, for example, I know of one community that has view restrictions. They owned property at one time, but they don't any longer. And consequently, their position is that they're not a Davis-Stirling HOA.
They wouldn't be. If there's no comment, and what you just said was all they have is they have is a mutual agreement or a contract between owners that live in a certain area to protect view corridors. But if there's no common area, they are not subject to Davis-Stirling. Right. They just have contractual rights vis-a-vis each other.
So that's a very big distinction to keep in mind. There's a very general question that I think is relevant to a lot of this, which is if there's some rule that just seems unreasonable, nonsensical, how do you go about challenging something like that?
Always, and this is what we tell our clients before they are clients. They come consult with us. We say, look, you can do this part yourself, or we can get involved. You write an email or a letter to the manager or to the board, depending on how your HOA is configured. In that email, you stay very professional. You stay non-emotional. You don't take shots because you got to assume a judge or a jury is going to read this. And you want to come across as reasonable. You don't want to come across as crazy. So you send them a letter saying, hey, you passed this rule. This rule is not reasonable for the following reasons. Here's what our CC&Rs say, or here's what the law says, depending if it's applicable. Please explain the basis that you guys have for passing this rule. because 4350 says the rule has to be reasonable. That is the number one rule for rules. They have to be reasonable. Reasonableness, by the way, is an objective standard, not the subjective standard. So if you have a person, let's say that's a vegan, that lives next door, has a very visceral moral hatred of meat, and you are smoking meat on weekends, or you barbecue, be truly a nuisance to them because it really bothers them, but that's a subjective issue. So they couldn't pass a rule banning that. It wouldn't be reasonable.
We want to obviously apologize to all the people whose questions we can't get to. There have been probably over 30 questions.
I am so sorry for talking too much. I apologize.
That's no problem.
I'm willing to stay a little later. I am.
I think anybody else should ought to just send those to you directly, because some of them are really specific things that probably are not of interest to the whole group necessarily. But we want to apologize if we didn't get to all those. But it was a great presentation, Michael. A lot of very interesting information. I thought your material is very well organized to present the whole picture of what's there. And I've done HOA law for a long time. And really appreciate you coming and putting on this presentation for the Beverly Hills Bar. And we want to thank everybody who attended for coming. Thank you all very much.